Welcome to review for Test 6. Let's start with the executive branch. Presidents have increasingly made use of executive orders because they do not need to be passed by Congress. You saw this in the State of the Union address when President Obama basically said to Congress, "You're not acting, so I must." And another reason is the president doesn't have to go through Congress to get one of his initiatives or priorities into place. The president appoints and the Senate confirms the chair of the Federal Reserve, which sets monetary policy. A pocket veto occurs when the president takes no action on a bill for 10 days during which Congress is adjourned, which is why a lot of times Congress will not pass something that they feel the president is opposed to right before they adjourn. Vetoes are difficult to override, especially when there is at least a 2/3 majority of the president's party in both houses of Congress, which is why a lot of times they don't even bother taking up a vote to veto a bill, override a veto. Two ways the presidents check the bureaucracy are by appointing cabinet heads and allocating funds to the agency. Remember that cabinet heads serve at the pleasure of the president, and when he allocates funds to the agency, he is saying that he buys into what they are implementing. Continuing with the executive branch, the chief of staff, the press secretary, and the White House counsel are all part of the White House office, which is part of the executive office of the president. The Attorney General is the head of the Justice Department, which is a cabinet position. He or she is appointed by the President and confirmed by the Senate. That is the only department head that is not called a secretary. For example, the head of the Department of Defense is the Secretary of Defense, but not in this case. The President has enumerated, inherent, statutory, and emergency powers. Here are some examples. Enumerated powers: Eisenhower sending the National Guard to Little Rock to enforce the Brown decision. Inherent powers: Thomas Jefferson in the Louisiana Purchase. We know that he was a very strict constructionist, and there was nothing in the Constitution that was going to allow him to purchase that land, so he went through his inherent powers. Or implied powers. Statutory powers are powers that are given to the president by Congress. For example, the line item veto, which we know was ruled unconstitutional by the court. And then special powers would be an example, would be executive orders. Even when the president has a unified government, which means that both houses of Congress and the president are all run by or have a majority of one party, it is difficult for the president to exercise legislative leadership because political parties and alliances are weak. So for an example, if you think back to 2008, there was a unified government because you had President Obama in the White House, you had the Democrats controlling the House and the Senate, but Harry Reid, who was the Senate Majority Leader, and Nancy Pelosi, who at the time was the Speaker of the House, not necessarily always on the same page as the president, so not everything got done. And lastly, for the executive branch, the Constitution authorizes the president to be the commander-in-chief, negotiate treaties, be the chief executive, and present the State of the Union address. Something that the Constitution does not authorize would be the head of the party, because the Constitution does not mention political parties. All right, let's move to the legislative branch. After a 2/3 majority of both houses of Congress, you would need 3/4 of the states to ratify a constitutional amendment. That is very difficult to do, which is why we only have 27 of them. The Franklin privilege allows members of Congress to mail information to constituents at public expense. This is part of the incumbency advantage because you can't do that if you're a challenger and not in office. But this cannot be campaigning material. It has to be just basically touting what you've done for the district. Motions of cloture are used to end a filibuster and bring a bill to vote. So you have to get 16 signatures in order to get this ball rolling, and if you can get enough votes, then you can end the filibuster and bring the bill to a vote. Congressional district boundaries are usually redrawn every 10 years by the state legislatures after the Census Bureau takes the count of the population. Congress uses legislative oversight to ensure that executive branch agencies are carrying out their legislative responsibilities as well as to conduct investigations into possible wrongdoing. Oversight can take many different prongs, but this just happens to be two of them. The Senate Judiciary Committee will conduct hearings on judicial appointments made by the president. This is one way that it can check both the executive branch and then influence the legislative branch, because it can choose not to confirm a presidential appointee to the judicial branch. Additionally, Congress can change appellate jurisdiction of federal courts, thus getting rid of a liberal or conservative judge. Both the House and the Senate establish federal courts, so that's a shared power, and they can also propose legislation and vote on the passage of a bill, all shared powers. The necessary and proper clause has broadened the power of Congress because this is where you get your implied powers, your elastic clause, things that are necessary and proper, defined differently by each generation. Even though some would argue it is pork, members of Congress like to direct federal funding into their districts through legislation because it helps get them reelected. Anytime you see a congressman's name on something, that's because they got money from, whether it's the state or the federal government, to do a project, and we always are excited about our congressmen when they can get us a project to spur on jobs or rebuild infrastructure, helps them get reelected. When the President appoints a Supreme Court nominee, it must be approved by a simple majority of the Senate, so just 51 senators. It does not take a supermajority. The House Rules Committee sets the conditions for debate and amendment of the House. We've talked about that several times. That's basically their sole job, most important committee in the House. The Senate does not have a similar committee. There's only 100 senators, so they don't need that. All revenue bills must start in the House. That's just something that you need to know, that that's where they originate from. Standing committees are permanent committees, and this is where most of the legislating in Congress takes place. They're broader in scope because they're going to have many subcommittees underneath them. The steps in policy making include agenda setting, so that would be your first one. Then you have to formulate the policy, then it has to be approved. Then you have to spend some money to implement it, and then you have to implement it, and then you have to evaluate it. And that's in the evaluation process, that's where you get your sunset clauses. All right, so the judiciary. The Supreme Court will issue a writ of certiorari when it wishes to clarify an issue in which there is disagreement among the lower courts. In other words, let's say in federal court where there's original jurisdiction, they rule one way, and they're ruling on the facts of the case. And then it goes to the circuit courts, which is appellate jurisdiction, and they don't agree with the law applied to the case because, remember, an appellate court is not determining the facts of the case, they're determining the law of the case. And so they come up and they overturn a decision. So the Supreme Court is most likely to hear a case when there is that level of disagreement between the original jurisdiction original jurisdiction court and the appellate court. And they really only hear about 10% of the cases that are appealed to them. So if you hear that they granted cert, that just means that they sent a request to a lower court for the information. A district court has original jurisdiction, which I just mentioned. Original jurisdiction is where you hear the case the first time. That's where you're deciding the facts of the case. And then appellate court has appellate jurisdiction. That's where you're deciding the law. Was the law applied to the case properly? You are not deciding the facts of the case. No jury is involved. An amicus brief is a friend of the court brief, and it's used to influence the court on a certain topic. I think that you were arguing that in one of your last forums. And then these are often used by interest groups to sway the court's opinion on something. The Supreme Court can overturn lower court decisions, state legislation, acts of Congress, and executive orders. They cannot overturn the Constitution, so they cannot change the Bill of Rights, for example. Stare decisis means that let the decision stand. This encourages judges to follow past precedent when deciding cases, and this is going to be part of your judicial restraint. The U.S. Constitution, according to the Supreme Court in Roe v. Wade, implies a right to privacy because there is no given written right to privacy in the Constitution. They saw it through the Fifth Amendment, and thus it made abortions legal. The rule of 4 is used to determine whether a case should be on the court's docket. So that means that they only need to have 4 justices agree to put it on the docket. SCOTUS ruled in Citizens United versus FEC that independent campaign expenditures by corporations and unions are protected by the First Amendment. So that basically said that corporations and unions are people too and have freedom of speech because your campaign donation denotes a freedom of speech. A source of power for the federal bureaucracy is the ability to set specific guidelines after receiving a general mandate from Congress. So they're the ones that are implementing the policies, creating the policies and implementing them, once Congress has passed a very vague law. And we know that they're very vague because that's the only way they can get through Congress. 2 examples of regulatory agencies are the Federal Communications Commission, or FCC, and the Federal Aviation Administration, the FAA. And so they're going to be checking, for an example, that the airplanes are safe and that there are certain standards in place for air traffic controllers. And then the FCC, those are the people that are going to fine broadcast stations if they do something that is inappropriate or deemed to be obscene. like the wardrobe malfunction several years ago in the Super Bowl. Two examples of independent agencies are NASA and EPA. Independent agencies are oftentimes more narrowly defined function of the national government. Congress and the President create these agencies to fulfill one of several purposes. Some of them, such as maybe the Smithsonian Institution, were established to handle new governmental functions that did not easily fall within the purview of existing departments. Other and administrative agencies are going to support the work of existing department and agencies. Regulatory agencies are often cited for violating the constitutional principle of separation of powers because they have quasi-executive, quasi-legislative, and quasi-judicial powers. So they are making the laws, enforcing the laws, and then adjudicating them. So in other words, determining whether somebody broke the law for their policies. Administrative law is created by an agency when it creates the rules and regulations for a policy. When voting for a congressman, we oftentimes vote our party identification. So if we're a registered Republican, most of the time that's going to be the leading predictor of how you're going to vote. It doesn't necessarily mean that that's how you will vote, but it's the leading predictor of how you will vote. The government does not regulate negative campaign ads. We've talked about this 1.5 billion times. They regulate expenditures, they regulate donations, but they do not regulate negative campaign ads. One of the reasons that we have a two-party system is because we have a single-member district electoral system. So in other words, we only get one representative for our district. So in other words, we're in District 22 in the state of New York. So Congressional District 22. And we only have one representative. And because we only have one, we're less likely to vote for a third-party candidate because we don't feel like they'll be able to build a coalition in Congress. If no one wins a majority of electoral college votes, the House chooses the president and the Senate chooses the vice president, which is why we were worried in 2012 because the vote looked very, very close. And because the House is controlled by the Republicans, we feared that we would have a split presidency. We would have Mitt Romney chosen as president, and then because the Senate is controlled by the Democrats, that then they would choose Joe Biden. So that would have been the ticket had President Obama not won the majority of electoral college votes.